including a meteorological mast, substation and access tracks on land approximately 8 kilometres southeast of Dufftown. The inquiry is being held because there is an objection to this application by Murray Council. My name is Sue Bell, and I'm joined by my colleague, Trudy Craggs. We are the reporters who have been jointly appointed by Scottish ministers to hold the inquiry to consider this application under Section 36 of the Electricity Act 1989. I'll be leading this meeting, but Ms Craggs may ask questions too as we go through the agenda. Also on this call, we have a couple of helpers from DPA on the technical side. That's Stephanie and Craig, so they may pop in and out as needed to help us with the technical issues. We'd like to remind everyone that this meeting is being webcast live and will be recorded and stored as part of the DPA archive on YouTube and will be capable of repeated viewing. By participating in the virtual meeting, you are consenting to being filmed and to the use and storage of these images and sound recordings and any information pertaining to you contained in them for webcasting purposes and for the purposes of keeping historical records and making those records available to the public. Further details can be found in the DPA privacy policy, which is on the DPA website. Before we get into the meeting, I have a few practical points to highlight. Because this is a virtual meeting, can I ask you all to keep your microphones on mute until it is time for you to speak? Thank you. And also, if you could make sure, sorry, Mr. Christie, were you trying to say something there? No, okay. I would also ask that you put your mobile phones on silent during the meeting. Whilst you're speaking, if you could have your camera on, that would be much appreciated. We will be ensuring that you all have an opportunity to speak, but if at any point you wish to attract our attention, for example, because you're having difficulty with connectivity or hearing, it would be helpful if you could raise either a virtual or an actual hand so that we know that you wish to contribute something at that point. Please don't use the chat function because that won't be available for everybody to see. And depending on how we get on this morning, I'm conscious it's quite tiring sitting staring at the screen, so we may take a wee break. And if at any point people feel that they do need to take a break, perhaps to consult with colleagues, again, just let me know and we can accommodate that. So our role as reporters is to hold the inquiry, to consider the cases made by all parties, and to report to ministers with our recommendations. The decision will be made by the Scottish ministers. You may, throughout the course of the inquiry, have contact with further DPA staff, principally Laura Walker, who is the appointed case officer, and she will be the first point of contact for any queries and for distributing information. The agenda for today's meeting has been circulated by email, and can I just check that everybody's got a copy of that? Yeah, everyone had it, thank you. So as a reminder, the main purpose today is to discuss the practical and procedural arrangements for the inquiry, including timescales. We will not be discussing the merits of the proposals or parties' cases today. We'll be keeping a note of our discussions and we'll circulate the key decisions in a pre-examination meeting note. And obviously you'll have recourse to this recording to be able to remind you again of what we've agreed. The meeting notes will include details of all the deadlines that we agree and the key decisions. As we're taking notes, we may ask you to slow down when you're speaking or ask you to repeat what you've said to make sure that we have an accurate note of what is discussed and agreed. So I'd like to start by asking everyone to introduce themselves. And I'm going to start with the applicants team. So would somebody from the applicant please like to introduce yourself and those who are with you today?
Yes, so good morning. So my name is David Hardy, H-A-R-D-Y. I'm duly qualified as a barrister and a solicitor, but for present purposes, I'm a partner in CMS, so CMS Cameron McKenna. So from our side, I am supported by Catherine Nolan, who's a senior associate with CMS, and then Poppy Watt, who is an associate with CMS. They're both, I think, on the live stream. And then in terms of client, you can see Kirsty Clark on your screen. And we also, I think, have Simon Herriot, the planning consultant, who again is on the live stream and watching.
Okay, thank you very much. Okay. And I believe we have representatives from two councils here. So could I perhaps start with Murray Council to introduce yourselves, please?
Morning, I'm Aileen Scott, the Service Manager for Legal Services, and I'm accompanied by Neil McPherson, who's the Acting Planning and Building Standards Manager.
It's nice. Yeah, thank you. And then for Aberdeenshire Council.
Yes, good morning, ma'am. My name is Rob McIntosh. I'm a Principal Solicitor at Aberdeenshire Council, and I'm accompanied by my colleague Elizabeth Tully, Senior Planner at Aberdeenshire Council.
Thank you. Now, I believe that we're joined by several interested parties who've objected to the scheme. So I'm going to sort of call out the names of those that I believe should be here today, and then if I've missed anybody, we can pick up on that. So I'm going almost alphabetical and starting with Mr. Ewan Cameron.
Yes, good morning, everyone. Ewan Cameron. I'm representing the local community. I'm a professional engineer and operations manager working in the energy sector.
And can I just check, you said you were representing the local community. Is that a community group or particular named individuals?
So it's a collective group of the Cabrick individuals, and also in collaboration with the Cabrick Trust.
Thank you. Colin Mackenzie. Mr. Mackenzie not on the call. Oh,
Hello, I'll unmute my mic. Thank you.
Thank you very much, Mr. Mackenzie. Thank you.
I'm Colin Mackenzie. I'm a retired chartered architect and local resident who has an interest in the impacts locally.
Thank you very much.
I'm also supporting the Cabrick Trust.
Okay, thank you. If we could come to the Cabrick Trust now, I believe we maybe have Mr. Christie.
Yes, good morning all. Lovely to see you all on the screen. Jonathan Christie, Chief Exec of the Cabrick Trust, which is a local charity leading a regeneration initiative in the Cabrick, supported today by Chris Hoyle, Solicitor from Turkinconnell, and Trustee Lynn Staples Scott. In absence, we have our counsel for this public inquiry, James Finlay KC, who is unavailable today. So between the three of us, we will participate this morning.
Thank you. And could I just clarify, Mr. Christie, obviously we received your email yesterday indicating that the Cabrick Trust was representing itself rather than previously, I think your objections had come through Mr. Kelly. Mr. Kelly's representation was stated he was also representing a wider group of people, also Belcherry Farms Partnership and Cabrick Community Association. Are you also representing those two other groupings, or are you just representing the Cabrick Trust?
Yes, the Cabrick Trust is essentially taking on the anchor role for a wider group concern, including the Cabrick Community Association and Belcherry Farms Partnership, and of course working with near neighbours, Colin Mackenzie, Ewan Cameron as well.
Okay, thank you for clarifying that. That's helpful. And then Mr. Steve Wright, I believe. Thank you. Mr. Wright not with us. Okay. Thank you. Okay, thank you. Is there anyone on the call that hasn't been introduced and that I've missed? Speak now. Okay, great, lovely. Thank you, everyone. So we'll move to item 3 of the agenda, which is the Code of Practice for Handling Inquiries under the Electricity Act. So there are no prescribed rules for conduct for inquiries held under the Electricity Act. However, DPEA has published a Code of Practice for handling inquiries under that Act. The code is modelled on the most up-to-date procedures that apply to inquiries as set out in the Town and Country Planning Appeals Scotland Regulations 2013. It sets out procedures to be followed and aims to ensure that proceedings are conducted in a proportionate, fair, transparent and efficient manner. A link to that code of practice was circulated in the agenda, and we'll provide that link again in the note of this meeting. And you can refer to that as we go through the process, just to provide further guidance to you on matters and how we will address them. So following this code of practice, we will adopt a hybrid approach in order to conduct the inquiry in the most efficient manner. This means that issues that can be dealt with on the basis of written submissions, or they might be dealt with by a hearing session, or for issues that require cross-examination, we will deal with those through an inquiry session. And the agenda has set out our provisional views on the issues that require further information or evidence and our proposed procedures for dealing with them, and we'll talk about that a bit more under item 5. We'll seek your views on the procedures to be adopted and the likely duration of proceedings, and fix a timetable for this, including the dates of any hearing or inquiry sessions. And again, we'll discuss those later this morning under items 6, 7 and 8 on the agenda. And so before we move on to actually sort of get into the meat of the meeting, can I check if there are any questions about the proceedings and what we're going to cover this morning? Okay, great, lovely, thank you. So we're going to start with item 4 then, which is additional information. And you'll see that we listed various things on the agenda. So I suspect this might take us a little while just to wade through and see where we are. I'd like to start by with the applicant by clarifying the position in respect of information that's been provided since the original environmental impact assessment report was published. And our understanding is, based on your position statement dated the 28th of November, that supplementary environmental information was published in November 2024, and you very helpfully provided a list of that information and how it relates to the earlier environmental impact assessment report. And we also note that in that position statement on page 17, you said there's no further environmental information pending. So now just check with the applicant, first of all, is that correct, that we've got the supplementary environmental information? You don't think there's any more environmental information to come?
Yes, basically what I've done is, and I would quite like to go through the detail of the individual topics. There is a question mark over landscape and visual stroke cultural heritage. So I can confirm in the round nothing for the other topics and tell you why, but I just want to put the caveat in for L&V.
Okay, right, thank you. We'll perhaps come back to that. I just want to check some other points, and we've got some points that we'll want to pick up on the information. But I'm going to come to Mr. Cameron first of all, because we happen to note from your position statement that you felt that the applicant's summary was outdated and was relying on information dated between 2021 and 2022. And I just wanted to check whether you had seen and were aware of the supplementary environmental information that was published in 2024.
Yes, I have. I've reviewed the supplementary information, but I still believe there are material changes that have happened in the community that actually would necessitate a date to the assessment to capture these items. Those summary-wise are the approval of Cabrick extension, the pending application of Burnell extension as one which impact landscape visual. There have been some work done on historical research on Craig Dorney that makes a change. There's the Cabrick distillery, which is now operational, which was not operational previously. And then I also believe that there is a significant concern with water security, from the delivery of water security with the increase in number of planning applications for wind developments in the area. And I'm actually preparing a position paper or statement to supplement it back up that information, which I'd like to submit in the next few days once I've got it completed.
Okay, right, thank you. We'll perhaps come back to some of those points as we go through the agenda, but that's helpful to know that you've seen that information. And can I just check that everybody else has also seen the supplementary environmental information? Yeah, okay, that's helpful. We just wanted to check up on that. Okay. Okay, before we follow up that train of thought in terms of whether there needs to be an update to the situation for certain matters, there are points that we have picked up from the representations so far that we wanted to clarify in terms of information that we believe might have been produced between the supplementary environmental information and now. And I want to start first of all with noise, if I could do that. So in the position statement that the applicant produced to Scottish ministers dated the 1st of September 2025, I think your box 21 and section 6 deals with the topic of noise there, and reference is made in that to a meeting with representatives of Murray Council and to additional information which related to noise, which was provided to them. So I suppose our first question is there any further information since that referred to in that earlier statement that's been provided to the council since the 1st of September 2025? You're on mute, Mr. Hardy.
I was so no. So the noise limits were established using environmental data included in the November 2024 submission. So correspondence with the council was signposting rather than the provision of additional information. So the answer is no.
Okay, thank you. So what you're saying is that there was no additional information provided above and beyond what was in the supplementary environmental information?
Correct, and we don't believe there is anything else required.
Okay. Well, that's helpful. So could I perhaps then turn to Murray Council and just check that you are content also I suppose we need to know roughly what the substance of that correspondence was. If it wasn't new information, was it clarification?
Yeah.
Murray Council, can I have your, yeah.
Yeah, since that point, and even towards the turn of the year, the applicant's been working with our environmental health colleagues just to refine information and do the calculations, and essentially getting to the point now where we have a potential suite of conditions. So whilst there's no new information per se, and they have been collectively working on the information that's submitted to arrive at a suite of conditions that may be imposed.
So just so that I understand, if there's no new information, what sort of nature of those discussions been taking? Is it, we have the predicted noise impacts. What have the discussions been around? How mitigation for those, or
Yeah, so around modelling, effectively using the information that's submitted, there's a kind of a discourse between ourselves and the applicant about how the upper limits are set, how you apportion noise to this and to say neighbouring developments such as the consented wind farm next door, Hill. So there's effectively there was communication and work going on about how you apportion noise limits and how that's modelled, how that's controlled. So not information, but effectively going through the process of basically attributing control of the noise that might occur. So the data was there. The last year, obviously, with the sort of shifting situation with consents or submitted applications, that was a moving feast for both sides in parts of last year. But certainly at the point now, as mentioned by Mr. Hardy, no information is required. And what we have done now is arrive at an agreement about how that collective noise be managed. So that's the work that's been ongoing, but instead of using the data that was in at that time.
I think it was a timing issue in terms of when the council was asked to consider the application and provide a response to the ECU. Was those discussions hadn't concluded, but they continued beyond that date and worked on the information we had, and we now have an agreement on what would be acceptable in terms of conditions.
Okay, right, thank you. So just so that to make sure I'm clear, it's basically to do with partly with the cumulative impact assessment and then recording of noise and how much you would then attribute to this particular proposal compared to any other wind farms in the area. Is that correct? In terms of setting the conditions?
Yeah, it's having a workable set of conditions which you can basically set a ceiling that they collectively have to comply with. And it's making sure that basically that was a workable solution. And obviously, for the Garbett decision was probably the most recent in that area. That was included in calculations last year, I think processed by. But yes, it was using the information that was there to arrive at manageable conditions.
Yeah, thank you. Yeah.
Just one question. Like, mentioned their Garbett Hill wind farm. I understand you're taking the information from the SEI and using it to inform conditions. Have you also taken account of what's in the SEI about the Clash and Dalek extension? or would anything further be required in relation to that to inform the noise conditions?
My understanding is that our colleagues did take that into consideration. That was part of the calculations for the close by clash extension. And that was when they worked out with the applicants and with the respective operators of the clash extension farm as well.
I can confirm that it was fully considered.
Okay. Can I just call in Aberdeenshire Council at this point, whether you've been involved or would want to be involved in those discussions that the Moray Council's been involved in about noise from the wind farms?
We haven't to date, but our main interest is in the forming of the conditions and the implementation of the consent. So we would like to be cited on and involved in any discussions.
But you haven't been to date?
No, not to this point.
Mr. Christie, I can see that you've raised your hand. Thank you very much for doing that. Would you like to join into the conversation at this point? It's the point you wanted to make.
Well, only a brief comment to confirm that the evidence associated with the apportionment of noise that was discussed will be shared. Purely noting that in relation to consistent comment from the Cabinet Community Association about the experience of existing noise with operational wind farms before considering both consented and the one we'll be discussing through the inquiry. So to confirm that evidence will be available.
Right, so you're asking the question whether that will be available. I think we would be don't want to leap ahead, but we'd probably be seeking more certainly written information about noise, and that would be available to everybody. So, okay, thank you. Does anyone want to say anything else about noise at this point? Mr. Hardy, I know that you said that you were wanting to run through each topic, but if you can bear with us, I just want to go through our list first. But if there's anything at this point you wanted to add about noise, feel free.
Noise, and in fact, the list I've got, it was designed to mirror the list that all the bullet points you got. So, no, nothing further on noise.
Okay, thank you. You content? Yeah. Okay. So we'd now like to think about whether there is a need for any additional environmental information, and Mr. Cameron's already given us an indication of some of the things that he thinks are necessary. So, Mr. Cameron, if I just sort of come back to you, you did very helpfully sort of run through a list, and you've mentioned particularly about other developments. Did you have particular ones in mind, or was it a generic comment about for cumulative effects?
Yeah, for the cumulative effect, obviously the most significant development in recently has been Durnell Extension, which is adding another 67 turbines to the combined development infrastructure there. From a cumulative effect, that's going to have a significant impact. My main concern is round about water security in the upper Devon Valley, and the fact that the headwaters of the Devon are now surrounded by turbines and wind developments. And in the regulations, it talks about specifically about pollution and whatnot. One of the key elements in the regulations is water quantity. In the assessment, there's no assessment on what the impact during drought conditions, which were experienced in 2025 and in previous years, and going forward, because there's the water supply of the Devon is very much based on rainfall and snowfall that's accumulated in the peat and the surrounding environment, with the area surrounded by wind farms and road infrastructure. It makes a significant impact on the supply. And if we see, which is the current trend of drier summers and whatnot, then I can see there's going to be a significant impact on water supply, primarily for the towns of Huntly and Turriff, which could certainly reduce the available water supply in those periods. I'm actually preparing a summary in further detail, which I would like to submit to the inquiry for review.
Well, we'll come to all the documents and bits of information we'll be asking for people shortly, but thank you for that. So you mentioned particularly Garbett, particularly water and cumulative facts. Before I come to the applicant, it might be helpful if there are any other parties want to join in the discussion at this point, and that will allow the applicant to sort of deal with those all together, because there may be some overlap. So if I start perhaps with Murray Council, is there anything that you feel is additional requirements in terms of any updates to environmental information?
No.
I know, sorry.
No.
Okay. Aberdeenshire, I know you're interested primarily in conditions, but is there anything at this point?
Not at this moment.
Okay, thank you. Mr. Mackenzie and Mr. Christie, you've both preempted me, but I will go in the order of your hands. Mr. Mackenzie, you're on mute, Mr. Mackenzie.
Sorry. Yes, picking up on cumulative effect, I think it's a material issue that now Garbett and Clash and Darragh extension have been consented, and that all the photorealistic imagery that's been created should reflect that in those views that incorporate those two consented developments.
Okay, thank you. And Mr. Christie.
Purely to confirm, in case it was missed by Ewan's earlier input, yeah, the position on Clash and Darragh extension being confirmed, Garbett Hill being confirmed, the arrival of Dornell extension to full consideration by the ECU, the status of regeneration developments within the confines of the Lower Cabrich, and the final one of note would be the ongoing work associated with Craig Dorney Hill Fort, which has been ongoing across recent years in terms of archaeological work.
Okay, thank you. So, Mr. Hardy, would you like to respond to your views on those items that have been identified for potential updating?
Yes. Do you want me to run through the other matters as well to get those out of the way and deal with it all? All going to be, we don't think there are, but so I've got aviation light.
Back to I think we'd like to come back to aviation lighting. Well, let's go through your list and then we'll pick up things as we go through.
Okay, then right, aviation lighting. So straight in, we say that we don't think anything further is required following removal of the Ministry of Defence objection. In relation to statutory consultees, there was a question about the Marine Scotland Science and Fish. Again, we say no additional information to be provided. There was a consultation response in the River Devon District Salmon Fishery to the Fishery Board within, I think it's table 7.1 of the 2022 EIA, and that refers to a fisheries management plan, and that would be produced pre, during and after construction in relation to fish. But the short point is we don't think anything is required there. Economic impacts and the council, Moray Council, we don't think there's anything required. If the council disagrees, then we would, through you, ask what that is. As you will be aware, on the SEI included a community wealth building report, and we consider that that addresses the point so far as it needs to do for economic impact. So economic impacts, we say no. RSPB, goshawks, there was a question about that. That was asked, and then we believe that that was answered satisfactorily within table 6.1 of chapter 6 of the SEI, and we are of the view that that matter has been resolved. In relation to hydrology, and I've just obviously listened to what's been said, we don't consider that anything further is required. We spoke to the consultants, so that's Ramble Hydro team, as recently as yesterday, and they don't believe that any additional information is required based on the comments from Mr. Cameron's position as it was set out and as those comments relate to water supply. So that then takes us to L&V and so landscape and visual, and then cultural heritage. Clearly, there are a number of comments in relation to cumulative effects. And hearing that, I think what we would be inviting you to do is to ask for an updated map identifying other projects for cumulative assessment purposes. And we are suggesting a 15-kilometre radius. And we would then, once that's been done, be in a position to confirm in relation to both L&V and potentially heritage what may need to be done in respect of cumulative effects. But I suspect the outcome of that will be that there is a requirement for FEI, and that seems to be the mood in the room, that needs to be updated. We also, it's a small point, but we also feel that we need to provide an updated map showing where the viewpoints are. So we'll come on to site visit later on. But if that's going to be unaccompanied, there is, I think, a slight difficulty in working out exactly where the viewpoints are. So it's a small point, but we would want to do that. So in short, nothing other than landscape and visual and cultural heritage, and that is to include both a map and then to take a view, but it is very likely that we will be doing, or we would be providing an update in relation to those two matters.
Okay. Can I just take you back, first of all, to the aviation lighting? And you mentioned to me the removal of the objection from the MOD.
Yeah.
I'm not clear, well, we're not clear totally whether the MOD have removed the objection on the basis of some lighting being installed, and what we're not quite clear on is whether the MOD has seen and approved the same reduced lighting scheme that's been approved by the Civil Aviation Authority, or whether there is still a process to be gone through there, if I can put it that way, of getting an agreement with the MOD about a lighting scheme.
No, my instructions are that there's not.
So MOD haven't agreed, or they have agreed.
They have.
Sorry,
Yes.
They have agreed.
Yes.
Okay. Well, we may well be seeking verification of that, I guess, as part of our further information, because I think the last communication we have seen says that MOD would remove the objection, providing that a condition was put in place for lighting. And obviously, we're wanting to be sure whether that would mean a change to the lighting scheme that has been assessed in the landscape and visual chapter for nighttime lighting. I don't know whether you're able to add any comments at that point.
I mean, I can't add any more. Those are my instructions, and that's my understanding at the moment. Obviously, if I'm wrong on that, I'll stand to be corrected, but that is.
Okay. I don't know whether
maybe just turn that on its head. Has MOD approved the scheme that has been assessed in SEI? Aviation lighting.
Yes, my understanding is that the MOD did not have any comments on the scheme when the condition was agreed. So the answer is yes.
Okay. And just to be crystal clear, that the assessment that's included for nighttime lighting is the scheme that has been approved by CAA and the MOD. Yeah. So there is no need to update any of the nighttime.
Correct.
Okay. Can I just check that the council, particularly Murray Council, are content with that situation as well? That's your understanding. You're content that the photo montages of the night lighting are correct.
Yes, obviously, given our rules of consultee in the Section 36 process, we don't overly review or scrutinise the MOD's responses to lighting. If they've withdrawn their objection, we're working the premise that they're happy with lighting that's proposed, and that's reflected in the SEI.
Mm-hmm. Yeah, it was more in terms of whether, from a landscape and visual point of view, you were content that you had sufficient information to be able to determine the effects of the nighttime lighting on landscape and visual receptors?
Yes, from the SEI, yes. Yeah.
Mr. Mackenzie, did you want to come in here? Or is that a legacy hand, as they say?
Oh, must be a legacy hand, sorry.
Okay,
No,
right, that's fine.
I don't have a hand raised, I don't think. Do I?
Oh, there's one appearing on our screen, but okay, it's gone. Excellent. Thank you very
Okay,
much.
sorry.
Okay, no, that's fine. Okay, so I think everybody content on lighting? Yeah, happy with that? Yeah. Okay. Marine Scotland Science, you've dealt with that, Mr. Hardy. We may include questions in terms of just clarifying that written submissions. So just to be clear, the habitat surveys, the fish population surveys weren't carried out, but there is a fish management plan which covers that issue off. Is that correct?
This is correct.
Okay, thank you. And then if I can come to the economic issue then, and again, I need to call on Murray Council because this was a point that was raised in your objection letter, although it wasn't a reason for objection, and the question about whether there was needed to be a net economic impact maximisation plan. Was that a comment directed in terms of something that could be dealt with by a condition, or was it information that you felt was necessary in order to remove an objection to the scheme?
It's not an objection, but however, it was just merely a response that we didn't think, taking on board the kind of commentary in policy 11 around local maximisation of benefit, that the submitted community wealth building statement didn't really give as much focus upon policy 11 as we'd hoped it would, nor did it reflect or comment upon Manor Council's own supplementary guidance on community wealth building, which has been available since 2023. We just felt that needed to be, if I apologise for the parlance, and beefed up to ensure reflecting the policy requirements. So we still think that's something that should be done. Written submissions, as I say, wasn't a point of objection for the council, but we just felt it was something that should be looked at further.
Okay, okay. Are you okay? Okay. Okay. And I think, Mr. Hardy, you've dealt with the response from RSPB. Thank you. So your proposal is that you are suggesting that we have an updated map showing cumulative impacts, and that we might then go from there for more information in relation to landscape and visual and cultural heritage.
Yes.
I'm just quite keen to sort of try and tease out at this point, if we can. There's obviously a great deal of overlap between the landscape and visual and the cultural heritage assets in terms of effects within the wider setting, if I can put it that way. Are you wanting to try and keep those two things separate? Would that be the applicant's position, or would you rather than try and bring the two things together?
They're separate. I mean, in terms of our position, we think it is more likely that there would be updates for L&V rather than cultural heritage. It may be that there are both, but they are distinct topics. They've got distinct policy basis and assessment techniques. So yes, it would be to keep them separate.
Can I just turn to the other parties? Where we will go and have a consideration, but I'm just keen to hear whether you have any further comments about that suggestion that's been made by the applicant, that we have an updated cumulative impact map, and then think further about what additional landscape and visual and cultural heritage information we might need. And just in terms of where people are appearing on my screen, Mr. Christie, I'm going to start with you, whether you've got any comments on that or any observations about that suggestion.
No, excuse me. Yeah, on board with the suggestion. The only build would be whether that indicates the other areas that might be impacted. So, for example, river health, ecology, water, and the refreshed cumulative impact position, whether assessments on those areas will then be needed.
So just so I'm clear, your view is that there would need to be some further information about cumulative impacts on water supply, and is that correct?
Water supply is the example, river health, ecology, fish was mentioned earlier on, and I think a situation where there is materially different green energy infrastructure in the area will have a bearing upon those factors. So yes, there may be additional work needed beyond just simply stating the refreshed cumulative impact position.
Okay. Mr. Mackenzie, do you want to add anything at this point?
Just other than a simple map isn't really, an updating of a simple map won't just be sufficient. As I mentioned earlier, I think the most photorealistic or the most realistic elements need to be updated as well.
Do you have specific examples of what you're thinking of in
yes,
that
all the
respect?
views from, for instance, the scenic highway, all those that include Garbett and Clashindarroch extension, which are photorealistic images, need to show the new wind farm and those ones together.
Okay, so you're suggesting new photo montages are needed to take account of the things that have changed?
I am.
Mr. Cameron, want to express your view on the suggestion? Yeah.
Yeah, so I think I agree with the others that a simple update of a diagram is insufficient, and there should be an updated assessment that captures all the elements of river health, water security, the archaeological works being carried out by Aberdeenshire Council, and the other items just discussed. So I think that's more than just a simple diagram. It needs to be a comprehensive update to the assessment to capture these points that have been raised.
Okay, thank you. Mr. Hoyle, I can see your hand up.
Thank you. It may be a point that you might want to discuss later, but I just wanted to flag at this stage the following advice from Council. The Trust would like to make a further legal submission on the absence of a joint EIA that takes into account the development and the grid connection. We're aware of a case that was heard in the Inner House in December last year, but it's not yet determined, and is expected to be an opinion in the next few months. And I should flag that our client would like to make a presentation on that in due course.
Yeah, that's noted. Thank you.
I mean, I know that case is in the court session at the moment. There is no judgment at this point of time. You think you're right. I think they're expecting a judgment probably in the next 2 to 3 months. So we'll have a think about how that may impact.
Thank you.
Are there any further comments about additional environmental information that people think may or may not be required before we leave that topic?
Mum, if I may just
You carry on, sorry.
if I may just respond, I perhaps hadn't made myself as clear as I had thought. We weren't suggesting that we would stop with just a map. What I was suggesting was that there was a map to identify those other projects which were within a 15-kilometre radius. But then on the back of that, the point I was making was that we are then very likely to need cumulative updates in relation to LNV and then potentially heritage. So I didn't want anybody to mislead that we thought that a map would, was all that we were suggesting. There obviously has to be substantive updating behind that. Can I also just deal with the Ratio Farm Limited case? That's a case I know very well because we're involved in it. And if there is a requirement, then that will have to be dealt with as well. Yeah. Right.
And Mr. Mackenzie, I can see you're the first person on the screen. Yep.
Thank you. You'll be aware of, obviously, that I submitted evidence concerning SSEN's assessment of the area in which the wind farm sits when they did their assessments for the Dornell connection, and the clear indication that, or the clear assessment that they and their assessors had made that this was a particularly sensitive area. and I've not had any answers to that. I think it's prima facie evidence that there's a discrepancy between professional assessors, and I'm just wondering what the status of those comments that I made and that evidence I submitted is.
How would we need to say that?
Well, that evidence is before us. So from all evidence we need to consider when we do our reports to ministers, we will be considering what we need to cover in our request for further submissions, and it may be lots of things like that we do pick up that we want further discussion on. It may be that it comes out with inquiry sessions, but we are aware of the position and the evidence you put before us, and we'll clarify in the note of the meeting the evidence we do require from parties, whether written or oral evidence. So just because we touched on something specific today, it's not because that's not important, or we haven't had regard to, or we haven't read it. We have read everything, and it's kind of informing all our views on what we need to take the case forward.
And yeah, Murray Council, your hand up.
Thank you. This is a more general comment, really aimed at assisting the inquiry and the timescales. Many will be aware in the call of the current state of play with the Dornell extension application, which is yet to be determined. There have been some responses given as yet when the council hasn't given theirs. Although all I wanted to flag to the inquiry was the scent in the air is that there's going to probably be very, very likely to be, off the back of the conversation so far, we're anticipating that there's going to be amendments to that scheme, probably affecting landscape and visual itself. We might well see amendments to the landscape and visual submissions for that wind farm as submitted. I don't have any other knowledge than the fact that we think that basically that if this applicant is preparing additional LA submissions to include Dornell extension, it may be pertinent to everybody, or for them in particular, to establish those situations with that current application. We suspect there's going to be submissions changes to that wind farm, and it's really just would it cause this inquiry a problem if submissions were prepared and submitted that were then superseded? Effectively, it's just my comment.
Okay, thank you. That's helpful to know. Mr. Hardy?
Just to say, well, that's extremely helpful. I mean, it goes further than that, doesn't it? There's the ability to we've got to be proportionate in all of this. There is the ability to rely on material that's being produced in other applications. So material which is being prepared for the Dornell extension not only needs to be right, factually correct, but also can be relied on. So I'm endorsing that just cognizance of changes or the up-to-date position with Dornell is useful and will save us time.
Okay, thank you. We will go away and consider that. So, in summary, we've got the suggestion of producing the updated maps as a precursor to determining what additional information might be required in terms of updating cumulative impact. The applicant's proposing that might be just limited to landscape and visual and cultural heritage, but we've also obviously heard the views of parties that might need to be a bit wider than that, and particularly including water resources within that. So we've got all that information from you now, and we will take that away and have a think about what we want to do with that, and we'll put our conclusions in the report for the meeting.
Can I just ask one point of clarification? Mr. Hardy, you say you're going to produce this map. Will you also produce a note setting out what you think is required at that point?
Yes.
Okay.
Yes. So it's not just going to be a map. Yeah.
Yeah. Just as context of the map, so we understand where the applicant's coming from.
Yes.
And it may be helpful at this point. Do you have an indication of timing of what this might look like in a timescale?
So the landscape consultant is not on the call. I'll see if I can take instructions while the call is going on, but I can't, I'm afraid, give you a date as to when that can be done by. But obviously we need to get on with it.
Yeah, so the first step of a map, is that going to take weeks?
No.
Maps that fairly quickly, you can pull that together, and then I guess, yeah, an understanding of the next stage of the process if we needed the additional information. So it would be helpful to get some kind of indication. I don't know if we're happy to
I was going to say, would it help you if we take a 10-minute break to enable you to contact your
I'm
landscape
not sure.
advisor?
To be honest, I'm not sure because so it is Samantha Oxley. I don't know what she's doing today. Is the honest answer. But I will take instructions from the client. And then I can do that in the background. I don't think there's any need to take a break in the meeting.
Okay. All right. Thank you. Well, we'll see how we get on. We may reach I won't say quite a crunch point, but the timing of that to fit into the process could be quite important, I think. Okay. If everybody's content then with that, we will move on to item 5, which is our provisional assessment of the issues to be addressed and those which might require further procedure. So, as I've already said, and as set out in the Code of Practice, the objective is that the inquiry is carried out in a fair, transparent and efficient manner. And to achieve that, it's helpful to identify the key issues that need to be considered and to consider the most efficient way of addressing those issues. And this might be through the process of written submissions, it might be through a hearing session, or it might be through an inquiry session. Annex A to the agenda set out our initial views on the topics which might require some form of further procedure, and we set out some suggestions for discussion as to what those procedures might be. Before we get into a detailed discussion about that, we're conscious that these procedures and the differences between them may not be familiar to everybody who's on our call today. And so I'm very happy to explain and expand on the different procedures if that would be helpful to those who are on the call. So I'll start with Mr. Christie, Mr. Mackenzie and Mr. Cameron. I'm looking particularly perhaps at you, and I'm not sure of your familiarity with the processes, whether you would find it helpful if I give a brief overview of the different processes that are available or not. Would it be helpful if I ran through what the different types are?
It would.
Yes, I would.
Yeah. Okay. So an inquiry session is the most sort of formal of the three options, if you like, open to us. So each party, so that's the applicant, both councils and any interested third parties, will each be invited to present its own evidence on specific topics, and you can call witnesses if you wish to do that. These witnesses can then be subject to cross-examination by the other parties, and us as reporters, we may also wish to ask questions. It's common, but not necessary, for parties to be legally represented, and in those cases, the legal representative will usually question their own witnesses and also cross-examine the witnesses of other parties. So it's quite a formal process. A number of documents have to be provided before those sessions take place, and those comprise inquiry statements, which set out the broad points that each party will want to make at the inquiry session, and precognitions, which are witness statements, which are prepared by each witness who's going to be giving evidence. So as I say, they're quite a formal process. Then another oral process are the hearings, which are much less formal, and they involve discussions, and they'd be more like today's meeting, really. They take the form of a structured roundtable discussion, which is led by the reporters. We would prepare an agenda before the meeting, so you know the questions or the areas that are going to be discussed. We'll then ask a question to one of the parties, and after that answer, we'll usually ask the other parties to put in any comments that they might have to contribute to answering that question. And there's normally then an exchange of views. When we feel we have enough information on that topic, we then move on to our next question. Participants in hearing sessions are required to submit hearing statements beforehand, along with copies of the documents that they're going to refer to, but they're not required to submit these witness statements, also called precognitions. And it's much less common for parties to be legally represented during a hearing, but they are able to have legal representation should they wish. And then finally, we have written submissions, and that doesn't involve any further meetings at all. We send out a list of questions to people that we think can answer the questions and provide us with the information that we need. And the answers to those questions are given to everybody to have a look at so that they have a chance to comment on them if they wish to do so. Sometimes we might start with a written process, and then if we feel that we're not quite getting the information we need, or we need to sort of have a bit more of a discussion about it, we would then move on to either a hearing or an inquiry session. Are there any questions about those three different processes? Mr. Cameron, okay? Yeah, Mr. Mackenzie, okay?
Yes, that's okay.
Could I just ask, in the oral process, you mentioned documents can be submitted. Can digital media be submitted in terms of video evidence or video material?
Yeah, probably as part of your documents. I'm using documents in the widest, broadest context there. It could be a physical written thing, it could be an audio thing, it could be a visual recording, but for our purposes, we call them all documents.
That's fine, thank you.
Okay.
We just need to be sure that everyone can access any media. But yes, there's no problem relying on that as a document.
Yeah. Mr. Christie, you okay with the processes, the options? Yeah. Anybody else got any questions about the processes before we move into the discussion? Okay, thank you. So if we can sort of have a look perhaps at Annex A to the agenda and the list of different possibilities, and I'm conscious that we sort of now almost added in an extra process with our maps, which might be produced. I'm just going to propose to sort of work our way down this list. So landscape and visual impact. We have the suggestion, obviously, of the map, and we might need to go for further process. But even based on the information that we have, we're proposing that it's likely, we believe, that we would need to clarify some points by further written submission, but an inquiry session might be needed. And we're looking really perhaps for some guidance from the applicant, but also from Murray Council as to whether you feel that the differences in your positions are sufficient, that they are going to need an inquiry session to cross-examine each other's witnesses, or whether there's perhaps broad agreement about significance of effects and it's more the policy issue that is the area where we need to drill a bit further. Can I start with Mr. Hardy?
From our perspective, we agree that there ought to be an inquiry session. Clearly, we will work with the council as closely as we can for statement of agreed matters and so on. But we think a short, focused inquiry session is needed.
Thank you. Murray Council, your views?
We would be happy if that's the reporter's decision. Our experience is that hearing sessions are often a better way to have a discussion around the specific issues rather than the formal cross-examination. I think the experience is that the evidence often comes out better in a hearing session, but we're in the hands of the reporters.
I don't know whether anyone else wants to chip in on that. We'll come shortly to who might be involved in different sessions, but I think there's probably the principal parties to be involved for landscape and visual. But if any other party has any comments to make about the process, now would be the time to make them.
A very quick comment, purely to note council advice our side was similar to Murray Council's position in preference of a hearing session, but can completely respect reporter's decision in that regard.
Okay, that's helpful. Thank you very much. Okay. We obviously need to sort of have a think about the information, and as I said already, we noticed the crossover between cultural heritage, particularly comments made about effects on views from Auchindoun Castle and Craig Dorney Hill Fort will come into the landscape and visual, but I've sensed that there is a strong feeling that people would like to see cultural heritage kept as a separate element, even though there will be a degree of overlap between sessions. Correct? Okay, thank you. So if we move to cultural heritage then, given we have the two scheduled monuments, we'd wondered whether people would have a preference for consideration of matters through an inquiry session, or whether there might be a preference for something, perhaps a hearing or further written submission. So I'm going to start with Mr. Hardy again. What's the view of the applicant about
Again, that justifies a focused inquiry session. We will, making the same points. We'll work with the council in relation to schedule of agreed matters and so on. But recent experience, they are different. Obviously, the policy is different. The assessment techniques are different. And put very shortly, L&V is looking at that as a contemporary matter. Heritage is obviously assessing significance. So they're two different topics, and we think they both justify short, focused inquiries.
I'll start with Murray Council. Do you have anything to add?
Yeah, our preference again would be for a hearing. We think that it is a very specific topic that we think could be dealt with by a hearing. We think that's more inclusive for parties who have views on the topics, and again, think it's probably a better way for some of the evidence to come out. It is a very specific topic, and we think a hearing would be better and also easier for some of the other parties.
Thank you. Aberdeenshire Council, I haven't asked you because I know you've already expressed in written form that you were mainly interested in conditions, but just to give you the opportunity here, whether you're wanting to say anything about cultural heritage processes. Okay, thank you. And then other parties, obviously cultural heritage has been, matters have been raised in a number of the objections, and on a broader sphere, if I can put it that way. So I'll start with, just go through each person in turn, I think. Mr. Cameron, do you have any comments about cultural heritage, whether it should be done by some kind of hearing process or an inquiry?
I obviously, inquiry has been the proposed method. I'm quite happy to support that for cultural heritage.
Okay. Mr. Mackenzie?
I'd be happy with either. My preference would be for the oral process, and obviously I think critical to the whole thing will be real world site visits to actually experience the views and the situation.
Okay. And there are two different forms of the oral process. So there's the hearing, which is like the we chat, less formal, or the very formal inquiry process. Do you have any views on whether you would have a preference on which of those two oral processes took place?
I think the informal one would probably be able to convey and discuss all the issues that I have an interest in.
Okay, thank you. Mr. Christie, do you have a view on cultural heritage and the best approach for that?
Yes, as noted, cultural heritage features within our wider community and regeneration concern, but as a standalone item, I think it has absolute merit. Again, much like Murray Council, I think the hearing approach makes good sense. The only other thing perhaps worth noting would be the capacity for further written submission or evidence. Here specifically, I'd cite Historic Environment Scotland designation report from 2024 about the expanded nature of the Craigdorney site specifically, and their recognition of it being of national importance. It would be good to ensure that that evidence is presented via the proper channels.
Okay, thank you. That's noted. Any other comments on cultural heritage before we move on in terms of process? Yeah. Okay. Okay, thank you. And so now then we move to to community effects, and whether we need some kind of oral process for that, or whether that could be dealt with by further written submissions. I'm going to start this time with Mr. Christie, whether you have any what your views are in terms of community effects, how you think that can best be addressed.
I think the proposed methodology cited within Annex A feel appropriate, and of course very happy to support.
So you would support a hearing on those matters?
Yeah, further written submissions, hearing and site visits being key.
Yeah. Okay, thank you. And Mr. Mackenzie, do you have views?
No, I agree with Mr. Christie that that's the best approach for me.
Okay, lovely. Mr. Cameron?
Yes, I agree with that. Further written submissions followed up by oral discussions on the topics themselves.
Okay, thank you. Murray Council, do you have any views?
We wouldn't intend participating in that session.
Okay. Mr. Hardy, now you've heard everybody else's view. would the applicant's preference be?
Yes, I mean, in most of the inquiries that we've dealt with recently, there has been a hearing session. That's tended to be in the afternoon or an evening in order to make that as inclusive as possible. I'm just listening to the mood music. That seems to be the design. We wouldn't object to that. It's important that people in the community have their say.
Thank you.
The only comment I would make is that those hearing sessions, although they've been called hearing sessions, have varied in the way that they've been run. So just thinking of a couple of very recent examples, one was in the form of a proper hearing where there was interaction and the reporters led the discussion and each of the parties then had their say and there were hearing statements and so on. In the other, it was much more like an opportunity for community members to say everything that they wanted to say. So there wasn't interaction. There was certainly no sort of discussion with the applicant. It was an opportunity for, in that case, quite a considerable number of members of the community to come along and say what they wanted to. So perhaps some thought to be given to whether or not we are looking at a hearing session proper, or whether we are calling it a hearing, but whether in fact it's a community evening session where people are entitled to have have their say.
Okay, thank you. That's noted. I'm going to turn, obviously, just to get some views on that point from the three community members of the community that we do have with us on the call. So, Mr. Christie, I appreciate you might not have been involved in the two different approaches that Mr. Hard has just summarised, but I think there is a clear difference there between a discussion like this, which is formalised in advance. People have advance notice of what each other's positions are, which is very helpful for the reporter, because then we can get ask some very targeted questions and understand people's positions accurately. Or what has been more, I suppose, perhaps would be more of a, dare I use the word, public meeting rather than a hearing session per se. What would be your preference? Do you think the view would be?
Happy to jump in first if that's useful. I think whichever forum that the reporter chooses, I think the importance is that it has robust standing in terms of its role within the public inquiry as a whole. I think when language around informal versus formal, it perhaps gives off a sense of concern that it has less weight. So whichever forum works best for the reporter and for the public inquiry is key, but just ensuring that whichever methodology we choose has genuine standing and is a robust process.
Okay, that's helpful. Thank you. Mr. Mackenzie, do you have an opinion?
I concur with that. I think my preference would be for the discussion and the ability, as I say, to talk about it. But I completely agree with Mr. Christie that if it's considered that the wider community should be involved, then so be it.
Mr. Cameron, do you want to express something?
Yes, I concur with the other expressions there, following direction from the reporters, whether that essentially for me it needs a more formal with the written submissions prior to, so we've got common understanding with everyone.
Okay, thank you. That's helpful. We'll go and have a think about that. Just to sort of help us with those discussions, our chat around cultural heritage obviously focused quite a lot there on the scheduled monuments, but I'm aware that other cultural heritage impacts, particularly the history of whisky distilling in the area, has been brought up, and I'm just keen to get a feel from people of whether they feel that would fit most comfortably within cultural heritage, whether that might be a better discussion as part of the community impacts. So perhaps I'll start with those people who mentioned it. Mr. Cameron, do you have a view about that?
I think because it's historic, it should probably sit within cultural heritage. is a significant factor within the history of the council itself.
Okay, thank you. Mr. Mackenzie?
Yes, I agree with Mr. Cameron. It's cultural heritage issue, I think. It's interesting in that it's something that probably won't get, well, it doesn't get any protection from Historic Environment Scotland, but it is a very significant part of this region and should be considered.
Okay, Mr. Christie, obviously it's a current issue as well as a historic issue, so that's why I partly bring it up as to whether you feel it would fit better into cultural heritage or into the community effects.
Yeah, there's certainly kind of a very strong and clear crossover between the two themes. I agree with what Colin and Ewan have said in terms of the cultural heritage theme. I think from a community point of view, specifically regeneration, it's a material part of our socio-economic driven plans focused upon regeneration, whereby we're looking to tell that heritage story through the successful operation of the Distillery and Heritage Centre and visitor offer therein. So it does drift into the community and community regeneration objectives very strongly as well.
Mr. Hardy, do you have any views on this?
Yes, I mean, I hear the views and I understand them. It isn't a heritage issue in the sense that policy and assessment techniques would indicate that, that's very clear in relation to what are designated assets and non-designated assets. That having been said, of course, it's important. Absolutely, is it's it's stitched into the history of the area. It feels to me as though that is better raised as a community issue. That's not to denigrate it, but it's better raised as a community issue, and that will then have some tentacles extending into regeneration, into tourism, into economic benefits, and future of the towns and those sorts of things. So I'm absolutely not denigrating the issue. It is hugely important, but it feels to me as though that is a community issue. And whilst all matters are different, when I've dealt with community sessions for other schemes where there have been, I mean, without giving the scheme away, it was to do with the woolen industry and the impact of, catch all of that. That was dealt with in the community session in that way. So I think it's historic, of historic importance, but I don't see that as a technical heritage matter.
Mm-hmm. And just checking back in with Murray Council, I know you expressed a view that you wouldn't want to be involved with a discussion, necessarily a community hearing, but if the issues of regeneration were being discussed at such a hearing, might that alter your views?
It's not a topic, it's not a matter that we've raised as part of our submission, so we would have no remit to discuss those issues. Our view is it is more of a community effect rather than a cultural heritage, but if it is brought into the cultural heritage session, we won't be commenting on it.
Thank you. Okay. Right. Okay. Right. So noise. Oh,
Mr. Christie.
oh, sorry, Mr. Christie.
A very brief question, mostly driven by my lack of familiarity with process here. Would it be typical or atypical for Murray Council in this example not to participate in the community session, given the Cabrick is a community within Murray, and we've engaged heavily in processes with Murray Council such as local development planning, etc. Just in support of my understanding more than anything else. Thank you.
I think the council want to respond to that directly themselves, so I'll allow them to do so.
I'll be addressing that.
I mean, it would be very much a kind of case by case basis, but in this scenario, our role is to speak to the grounds for objection that were made by the council, and they are restricted to what was specifically discussed and agreed at committee. So yes, we are aware of the work that's been done by the trust and the wider impacts of that, but in relation to this specific inquiry, our participation will be based on the objection.
Is that helpful? to answer your question, Mr. Christie?
No, thank you, Aileen. That's much appreciated.
Okay, thank you. So the next topic then was noise, and we've sort of
sorry, could I?
Yeah.
Sorry, just in terms of the community benefit, just come back to the fact that we have raised the additional point in relation to maximising the benefits for the community. So that has been addressed, not as an objection ground, but for something that we do think there is the need for some further discussion on from the applicant, and we've already spoken about that. So we have had regard to that impact, but we didn't raise it as a ground of objection. Sorry for interrupting.
No, that's fine. Thank you very much. Yeah, okay. So moving on to noise then, we've touched on that already. We've identified that we would seek some further information by further written submissions, and that may be just clarifying what we've discussed really very much today. And then I guess, depending on what comes out of our cumulative map of updated position, there may need to be a discussion about whether there would be any further information required about noise. But at this point, we're just anticipating further written submissions. Anybody feel strongly differently? I'm going to start with the applicant this time and work my way around. Mr. Hardy.
Yes, we, on a protective basis, thought it might be sensible to reserve half a day for a potential hearing. And it's for this reason. You'll probably be aware that ETSU is in the process of being updated. So ETSU R97 being the principal guidance document that regulates the control of operational noise from wind turbines. And that is looking at the draft of ETSU, likely to include changes in methodology. It raises matters such as blended rates. So instead of having daytime and nighttime separated out, having single blended rates, and other matters, including cumulative. The expectation is that in the period that we're talking about, in the 6 months that we are looking at through to sort of June, there is a likelihood that that's going to come out. So, and if that did come out, we don't think that that would be sensible to deal with in writing. So our suggestion was to have a half day reserved as a hearing to mop up all matters, but with one eye on that policy change.
Okay, noted. Thank you.
If that doesn't happen, and it is just on the material that we've got here, then we would be suggesting that we revert to written representation. So just to be clear, I don't think there's anything in what we've got now that would require that hearing. It would be on a protective basis because we can see that coming down the tracks.
Okay. Thank you. Any comments from any other party at that point? I'm going to turn first of all to Murray Council, given that I know that you've been having discussions about the analysis of data.
We've been aware of that prospective change in legislation too. Speaking to our mental health colleagues, yeah, there is that possibility of the change that's your guidance. No, not wholly opposed to what Mr. Hardy is suggesting. However, I'm mindful of our resources, and quite frankly, we think that probably could be dealt with by written submissions, or it could even be something that's touched upon during the conditions hearing session, if that's the way that goes.
Thank you. Okay. Does anybody else want to chip in at that point about noise? As I say, our initial proposal is further written submission. We've had a suggestion that if the rules change, then that might need a hearing. Mr. Christie.
Fairly to note that we'd most likely revert to council following further written submissions being tendered. I agree, possibly on a different basis to Mr. Hardy in terms of the potential need for a hearing. So over and above any guidance changes that may be forthcoming, I think the lived experience expressed by the Cabinet Community Association is quite material. That's in relation to current green energy infrastructure. So again, I think hearing current status alongside what's being proposed via a hearing session could have merit. But as I say, we'll take advice from council off the back of the further written submissions.
Okay, thank you. Mr. McIntosh.
Just briefly, just saying that we'd like to reserve our position on the noise until we've had further discussions with the applicant and Murray Council, because that may have implications on proposed conditions.
Okay, thank you. Okay, so I think I've got a good idea of what people are thinking of that. That's helpful, thank you. So yeah.
Mr. Cameron, you did raise noise in your objection. What's your position on this?
It's the same as Jonathan Christie's position, that there is empirical data from the community on the existing infrastructure that causes nuisance, and that will be considered in the evaluation and hearing.
Thank you. And sort of following on but separate, we've identified shadow flicker to pick up on various comments that are made in objections. We think that this is something that could be dealt with by further written submissions at this stage. I'm just seeking any other views on that point. I'll start with the applicant and then work around.
I think, ma'am, I mean, if at all, I think our view is we don't really think anything is necessary, but if there was going to be something in writing, could we make that as targeted as possible? Just from, I mean, years and years of experience, but shadow flicker isn't something that tends to take any time up, given the conditions that would be proposed. So, not objecting, but if we could just make it as focused and targeted as possible.
Yeah, that's noted. Mr. Christie, any comments?
No, as per the last theme, we'll take advice from council off the back of written submissions, but would anticipate on that theme that further written submissions is sufficient.
Okay. I think this was an issue. Mr. Cameron, you mentioned shadow flicker. Am I correct in your submission?
Yes, I would need to review further written submission, make an assessment on that. It is very specific to locations that are impacted by the shadow flicker effect, and particularly times of year as well. For
but it's something we can deal with, in your view, by further written submissions. Thank you. Mr. Mackenzie, do you have any comments?
No, I've no comments to make on that. Thank you.
Thank you. And just check in with both councils. I'll start with Murray Council. Is it something that Murray Council would want to be involved with further written submissions?
No, thank you.
No, thank you.
And none, not from Aberdeenshire. Thank you. Well, thank you. That takes us to transport, and we again note that there have been some discussions, I think, perhaps that have happened, or an opportunity, perhaps I should say, for Murray Council's transport team to look at the information that was provided as part of the supplementary information that maybe we haven't yet received. So we're anticipating just perhaps a need for further written submissions to pick up on that. But we're happy to listen to any views as to any different positions on that, or whether there's a feel for anything further requiring information about transport. I'm going to start with Murray Council, I think. Sorry, I can see you in the middle of the discussion. So transport, we're suggesting further written submissions just so that we understand, I think, where things are from the council's point of view with that issue.
Yeah, although yes, from Murray Council's perspective, yeah, it's identified as a grounds for objection just because at the time that we had to reply to the energy consensus unit, we hadn't bottomed out yet our assessment of the SEI in discussion with the applicant. Our clarification colleagues have now included their assessment, and our submissions would just be in the form of suggesting the conditions that would cover all the various issues that were raised. So happy written submissions to be the vehicle for that. That would also be in tandem with any condition session.
Mr. Hardy, I'm going to come to you next. Oh, lost him. He's dropped out of the meeting. You just on the wrong button. We'll just give him a moment to see if he manages to join back in. I don't think transport was mentioned, especially in other representations. So just whilst we're waiting for Mr. Hardy to come back, I'll just check that Mr. Cameron, you wouldn't have any comments on transport.
No specific comments on transport. Would similar you had written submissions.
Okay, thank you, Mr. Mackenzie. I'll come back to you in a minute, Mr. Hardy. I'll see you back.
Yeah,
Mr.
sorry,
Mackenzie?
I haven't really looked at the transport side, but it occurs to me, that I hope a cumulative assessment would, now that Craig Watch extension Clash and Darragh extension has been granted, the cumulative effect up the local road is going to be a material consideration. That I presume the transport plans for both these don't overlap, or if they do, it's considered.
Thank you. Mr. Christie?
You're all comfortable with what both Colin and Ewan have raised there? Agreed.
Okay, thank you. Mr. McIntosh, did you want to come in on transport issues?
Yeah, it was just to say that if there is any updated transport assessment that's been submitted, if there are any transport implications for travelling through Aberdeenshire, that if we could be cited on it, so we could take a view from our own transport colleagues, and then we'll pick it up in the condition sessions.
Okay, thank you. Mr. Hardy, welcome back. I don't know what happened there. Sorry.
It was just a complete sort of spasm. I don't know. Anyway, back.
We wondered if
so
the officers got clicked.
No, I don't know what. Anyway, so the officer confirmed nothing further is needed. So our view is don't perhaps need anything, and that could be picked up in conditions.
Okay.
I'm not sure it justifies anything at all.
Okay, thank you for that. Okay, that takes us then to energy policy. And we've again identified some further written submissions on this, just to make sure that we're all happy that we're fully up to date. We don't know whether, we don't think at this point that further sessions are required beyond further written submissions, but let's start with the applicant first of all and work our way around.
Yes, this is an interesting one. I mean, the trend recently has been not to have any type of oral procedure, and where you do get them, we find that useful. And so our suggestion is going to be for a focused and targeted event, and we suggest that would be dealt with in half a day. I also just note and want to explore the reference to energy policy and to seek clarification whether that is just energy policy or whether that is energy and planning policy. Clearly, there's a significant overlap between matters such as L&V evidence and heritage evidence and policy, such that we would want to consider evidence on those matters in responses to policy questions. So where we don't need to trot through all the general stuff, that isn't helpful, but we have found it useful to have a targeted session on policy dealing with those sorts of matters, so both energy and planning policy.
Okay. By targeted, I might have missed it, Mr. Hardy, so excuse me if I have. Were you suggesting a hearing or an inquiry for this targeted oral session?
Hearing, but with an agenda from what's worked really well has been an agenda from the reporter with, it's typically been 8 or 10 questions, and they've been quite wide ranging actually. They could be community benefits, it could be there's lots of, and that has provided an opportunity in some of those cases where there have been community issues raised for reporters to ask in a policy context where or how much weight might be applied, I don't know, to the tourism aspects of whiskey distilling, those sorts of things, because they are policy matters. So we think it's a good opportunity to deal with both energy and planning.
Yeah, okay. Yes, that's helpful. Your comments. I mean, one of my questions was, should it just be energy policy, or does it need to be wider ranging? So your comment that you feel a little bit wider ranging has been helpful.
Yes.
Murray Council. I lost the council. Oh no, you've moved on my screen. Apologies. Do you have any comments?
You can lose us if you like, but we're
not
sure.
at all. You just moved around.
We feel the policy issues have been addressed in our committee report, which has already been submitted, and we wouldn't intend to be involved further.
Okay. I'll just check with Aberdeenshire Council. Your focus is very much on conditions, but I'm just checking that you wouldn't want to be involved in a policy discussion through written submissions.
That's correct. We won't be involved.
And then Mr. Christie, two questions, I guess. One is, would you be content for the policy session to cover energy and also wider planning policy? And the second question is, whether you have a preference for whether that should just be addressed through further written submissions, or whether you would accord more with the suggestion from the applicant that perhaps there would be a very targeted hearing session on policy matters.
So yeah, in terms of the first question, I think definitely understanding the scope in its broadest sense that we're looking to cover within that theme would be important, and we can then review the written submissions off the back of that. Therein, I ask the question whether within that scope, need case and current energy statistics has a role to play within that. And if so, there would probably be written submission in that regard from ourselves. And yes, with council input, we'd then be able to decide whether a hearing session would be a pragmatic route.
Okay, thank you. Ms. Mackenzie, do you have any views on that?
I don't have any views. I don't anticipate participating in that discussion.
Okay. Mr. Cameron.
Similarly, no views on this.
Okay, thank you. Okay, and then that takes us then on water supply, which we have discussed in broadest terms, and in the light of certainly some of the objections that we've seen and our discussions today, our suggestion is that we would need to seek some further written submissions on this at this point. I'll come to you first, Mr. Hardy. I suspect I know what you're going to say, but what would be the applicant's preference?
Sorry to be boring. Yeah, we don't think anything further is required. If there are going to be representations, then could we ask for those to be focused and targeted, so we know exactly what we need to do in a proportionate way.
I'm going to start with the community and then come to the council, I think, this time. So, Mr. Christie, do you have any views in terms of how matters related to water supply might need further procedure?
Yes, so welcome further written submissions, and equally welcome the additional work that Ewan Cameron has cited that he'll be undertaking in this regard, and can consider that with council thereafter.
Okay. Mr. Cameron, your name's been cited. Do you want to?
Yes, so I've been in preparing a written submission for this. Specifically, it's more the cumulative impact of all the developments should they go ahead. And Craig Watch is part of that. Craig Watch is probably significantly more important because it is within the SEP water protection area as well, so it has a bigger impact. There's a direct association with the solution that I'll prepare.
And just to be clear, I mean, you've hinted that you're writing some stuff on this. It's a matter that you feel that we could get the information that we need through just written submissions. It wouldn't need any kind of oral process.
It may require some oral process to follow up after the written submissions, maybe to discuss and clarify a number of the points that are being raised.
Okay. Thank you. Mr. Mackenzie?
I wouldn't have any involvement in this. Thank you.
Okay. And then I'll ask each council, although I know it's not a matter that's raised in your representations, but just to check, Murray Council, would you have any comments that you want to?
I mean, we'd obviously be interested in any additional submission produced by Mr. Cameron, but we've got no remit from committee to discuss that.
Okay. And Aberdeenshire, likewise.
Likewise.
Thank you. And that brings us to conditions then. And we are proposing a further written submission session on that, followed by a hearing session. And let's start the other end for a change. Mr. McIntosh, Aberdeenshire Council, you would wish to, what are your views partly on whether it should be further written submissions and hearing, or whether you think something further is required, and whether the council wants to be involved?
This is principally the main area that Aberdeenshire Council wishes to be involved in, because we have not formally objected, but obviously we wish to ensure that we're content with the implementation of development, which would be by condition. So we would be interested in being involved with both the applicant, Aberdeen, and Murray Council as they're adjusting the conditions that were cited on them, so that we can also input into them. It's a well-kent procedure between applicants and the authorities, so we hope to work to come to a mutual reposition as much as possible on most of the conditions, and thereafter, if required, a very short focused hearing on any outstanding conditions or any questions that the reporters wish to have on any of the key conditions.
Thank you. Murray Council?
Yeah, I'm very delighted to volunteer Mr. McPherson for any further procedures on this. And I think written submissions to clarify any further discussions that have taken place, and a short hearing if it's needed, which often works well for conditions.
Okay, thank you. I'll ask the three members of the community. I should have made it clear that these discussions about conditions are on a without prejudice basis, so in no way does it indicate that it's a foregone conclusion, but as part of our report to ministers, we have to include a list of conditions should ministers decide to grant the permission. Is it a matter that any of the community representatives on the call would feel that they would wish to be involved with? So I'll start with you, Mr. Christie.
We'll take further advice from council on our side in terms of kind of what role the trust and the wider community would have in this regard. Of course, our position is to oppose. There is a scenario where the project goes ahead, and I suppose the imperative would be in such a scenario to ensure that that is done in a way that is as sympathetic to the local community as possible, and if that can be borne out via conditions, then I'm sure council will advise us accordingly.
Cameron?
Yeah, certainly. I'd like to view the conditions to ensure that any safeguards are included as required for any impact on the community.
Thank you. Mr. Mackenzie?
It's a difficult one, but I really don't think I'd be involved in that discussion, but I concur with Mr. Christie and Mr. Cameron regarding an interest in just seeing how best the community is protected by those conditions, but I don't really anticipate participating in it.
Mr. Hardy, what's your view on the approach?
Consensus. I mean, look, we would hope that conditions can be very largely agreed. What we can do and what we would propose to do, if this is acceptable, is to take a lead on preparing a draft schedule of conditions to forward to the council and anybody else that wants to be involved. There is a practical point there in relation to sharing of email addresses, so that those people that want to be involved in that process. So we would ask for email addresses to come through the case officer. What we've done before is a schedule, and then as things progress, there can be columns for to display where there are differences between the parties and what they are. So it's tried and trusted. It's worked before. We would hope that gets us most of the way there, with just those short residual matters being dealt with in a hearing.
Sue, it looks like you're on mute.
Is it Trudy having dropped off that's causing the issue? I think it was her mic that was the live one.
Hello, sorry, we're back. Hopefully, can you all hear me? Yes, great. Sorry, we've had a slight technical issue. What I was saying was that we have covered what we believe to be the issues that we need further information on, and for which further procedure is required. But this is your opportunity, should you think that there are matters that do require further procedure that we haven't highlighted, to flag them up to us. So I'm going to start with Mr. Hardy. Is there anything from the applicant's point of view that you feel that we haven't identified a further procedure for that we need to on? Okay, thank you. Murray Council, anything from your point of view? Aberdeenshire Council?
Yep.
Mr. Christie?
Nothing from our side at this stage.
Okay, thank you. Mr. Cameron?
All the points are covered, I believe.
Thank you. Mr. Mackenzie?
Nothing to add, thank you.
Lovely, splendid, thank you. I'm just looking at the time. It's 11:45. We've just got a few more things to do. Probably take us another 15-20 minutes, something like that, possibly, maybe a little bit longer. Would people appreciate a short break away from the screen, a chance for, to use our American cousins' phrase, a comfort break, and to come back to finish the agenda in, say, 10 minutes' time? Would that be helpful? Yes?
Yes, no objection at all, if that's...
Yeah, okay. So if we could try and convene again at, say, 11:55, then that gives everybody an opportunity to take a bit of a breather, stretch your legs, and see you shortly. Thank you. Okay.
Well,
Carry on then with item 6, which is participation in further procedures. And I'm hoping we can be fairly speedy because we've sort of talked about this as we went through the different topics. So what I propose to do is to go through those topics and just check that our notes are correct in terms of who wants to participate in those particular processes. So if I can start with landscape and visual impact, my understanding is that for the processes for that, we have, excuse me, Mr. Hardy, I'm not going to mention the applicant on every occasion because you're a given. So I'm going to start for landscape and visual. My understanding is that Murray Council, Mr. Mackenzie, the Cabrach Trust, Mr. Christie and Mr. Cameron would all want to be involved in that process. Is that correct? I've not missed anybody out there.
That's correct, yes.
Yeah, Mr. Christie, did you want to say something? Yeah.
Yes, just purely to for the avoidance of repetition, just to confirm that reference to the Cabinet Trust includes the wider group concern of Belheady Farm Partnership and the Cabinet Community Association.
Thank you. Well, I will. That's helpful. Thank you. Great. Cultural heritage. Then I think it's the same parties. Am I correct? The council do want to be involved in cultural heritage. So Mr. Mackenzie, Mr. Christie, and Mr. Cameron is my understanding at this point. Yeah. Great. For the community effects, I understand that the council neither council want to be involved in that session, but it would involve Mr. Mackenzie, Mr. Christie, and Mr. Cameron, in addition possibly to the applicant in that context, depending on the nature of that event. Yeah, great. Noise, my understanding is that everybody would want to be involved with that. Further written submissions, correct? Okay. Oh, Mr. Christie?
Sorry, I wouldn't be involved in that.
Mr. Mackenzie, you don't want to be involved with noise, that's fine, thank you. Mr. Christie, from your perspective?
I think involvement based on consultation with council and the further written submissions that have been noted.
Yeah, the further written submissions. And Mr. Cameron, then I'll just check you would want to be involved with the further written submission stuff for noise.
That's correct, yes.
Yeah, thank you. Shadow flicker, from our discussions, I believe that would be Mr. Cameron and possibly Mr. Christie, is that correct?
Same as last, in consultation with council and review of written submissions.
Okay, thank you. For transport, obviously that would be Murray Council for the further written submissions. I'm unclear whether the 3 community representatives would want to see site of the further written representations on transport or not. So maybe I can just check. So I'll start with Mr. Cameron. Would you want to see those?
Yes, I would like to review the further written submissions in transport.
Thank you. Mr. Christie?
Likewise, no harm.
Okay. Mr. Mackenzie?
Yes, I'm the same.
Yeah, and I remember Aberdeenshire Council would like cited those in case there's any implications for your council area. Is that correct?
Yes, that's correct.
Thank you. Then the policy session, I have that would be obviously the applicant, Mr. Cameron, Mr. Christie, Mr. Mackenzie. The council have said that their policy positions set out in the paper that went to committee, but perhaps you would like to see sight of anything that comes through further written submissions in case that would have an implication. Okay. Aberdeenshire Council, would you want to see sight of anything on policy matters?
No.
No. Okay. Thank you. Sorry, I'm just not reading my own symbols very well here. Can I just check, Mr. Cameron, would you want to see any representations on policy matters?
Yes, I'd like to view should the safeguards up there if required.
Okay, Mr. Mackenzie?
Not on policy, but on conditions.
Yeah, that's fine, thank you. Then the cumulative impacts on water supply or water supply generally, I have Mr. Cameron and Mr. Christie as wishing to be involved in written submissions on that. Is that correct?
That's correct.
Yeah. Okay. And then conditions, I have everybody wishing to be involved with that. Sound correct? Thank you. Well, hopefully we've got a correct record of that. I should say that this isn't your final chance. If you go away and then get the note of the PEM and think, actually, maybe I don't want to be involved in that session, you do have an opportunity at that point to change your mind, and put it that way. Okay. Let's move on down the agenda then. And deal with dates, locations and timings. And we obviously have a new element to allow for. And Mr. Hardy, I'm hoping against hope that you've managed to speak to your landscape specialist in terms of this updated map that you were proposing.
I'm afraid we've obviously tried to. We haven't got a response. What I can promise is that we will come back by email to the unit today. We've obviously tried, but I'm going to suggest in terms of drawing up the map and giving an idea of what needs to be done, that a couple of weeks is all that's going to be required. If it can be done sooner than that, then all well and good. I simply don't know where what Miss Oxley is, where she is at the moment, or whether she's on holiday or whatever.
Okay. So that might push everything back from our suggested timetable.
I'm not sure. I'm hoping not. I've looked at that, and in terms of timescales, do you want me to? Well,
yes. Go well.
15th of June.
Before we leap into that, let's just go back over when we've established where we were with those different procedures, and we have talked a little bit as we went along about how long we thought things might take. But I'm just obviously trying to get a feel for how long we need to allow for any oral processes.
Yes.
So I think that's just helpful if we reach some with lots of caveats, obviously, because we don't quite know yet the full scope of what might need to be covered through that oral process, our initial feelings. So if I can stick with you, Mr. Hardy. So landscape and visual, we've talked about the possibility of a targeted inquiry session. What sort of is your gut feel for duration of that?
Well, half to 1 day, I would say. I'm hoping, if we started at 10 o'clock, then maybe by mid-afternoon we would finish. And I've kind of put that together with heritage, albeit being separate. If you're having an inquiry session, I think that those would be a day and a half to 2 days together. We would then be looking at potential half a day for policy, when that's worked well before. Conditions is then followed on in the afternoon to do that as the last session, and then potentially half a day reserved for noise, and then the community session, if that was going to be it could be half a day, during the non-inquiry week, or it could be in one of the evenings, having a slightly earlier finish. So putting all those matters together, plus we would need conditions. So conditions after the policy. Putting all those matters together, I think it is still doable within 4 full days, but with the potential for an evening community event. If that wasn't possible, then it might slip over into a 5th day. The question then would become whether something like conditions or policy could be dealt with virtually. I think the other things absolutely do need to be in person and locally, but it might be that policy and conditions could be dealt with virtually on the Tuesday of a second week.
Okay, thank you.
In terms of dates, so 15th of June is the.
Can we come back to the dates, and I'll just
Yes.
say some other parties first. I
Yes.
think that would be helpful. Murray Council, obviously the duration of the inquiry sessions will be dependent partly on numbers of witnesses and that people will want to call. Do you have any views on, the suggestion is that the inquiry sessions might take 2 days in total for landscape and visual and cultural heritage? You'll have a better idea of the number of people you might want to call from your side on those matters. Do you disagree violently with that estimate of time?
No, probably we would say less. We only intend to call, we think at this stage, only Mr. McPherson. So we would anticipate being relatively short in terms of presenting evidence. We have suggested cultural heritage as a hearing, and we think a half day for that would be sufficient. So we would think probably a little bit less. And in terms of any hearing session on conditions, obviously there'll have been a lot of work done in advance in terms of the circulation of the paperwork, as Mr. Hardy suggested, and I appreciate other parties have an interest in the condition session, but in terms of wording of conditions, that really comes down to the councils and the applicant in terms of meeting the tests and obviously the reporters. So I would anticipate any hearing session on conditions could be relatively short, but as Mr. Hardy suggested, if that fell out with the timescale, that could be done virtually.
Okay, thank you. And from Aberdeenshire Council's perspective, what's your view in relation to the conditions session? Firstly, whether you feel roughly half a day, which is what's suggested, might be an appropriate length of time, and secondly, whether you would be content if that was done as a virtual process.
We'd be surprised if you needed half a day for it. That's just based on our recent experience where we've been actually quite proactive in agreeing with applicants, but obviously you need to build in a bit of time for our reporters to actually be satisfied on it and raise questions. Again, be supportive of actually moving to virtually, gives a bit of flexibility around it and would make it easier for us to attend. So happy with those suggestions.
Okay, thank you. Right, Mr. Christie, I'm going to start with you, bearing in mind that you may not be quite sure at this moment about numbers of witnesses and things like that. And I'm going to do it in the round, I think. Well, first of all, I'm going to ask you about the community hearing and timing of that, whether you think that would be better held as an evening event or whether an event during the day would still be accessible to people who might be interested to come and listen.
Yes, I mean, across all aspects of hearing or inquiry, we'll discuss in detail with council on the specific point around community. The forum that best allows maximum representation from the community with regards to current lived experience over and above the community regeneration objectives that we're leading, I think is important.
Thank you. Mr. Cameron, do you have any views on that?
No specific views on that, just notification of timing and stuff would be very useful from my perspective.
Okay. Mr. Mackenzie?
Likewise, I'll take my lead from those that are more experienced in these matters.
Okay. And at this point, as I say, you probably wouldn't have a feel for any witnesses that you might want to call on cultural heritage matters anyway to sort of get a feeling, but I think we've got some rough idea of timings for ourselves, so we can take that forward. Okay. Right. Okay. So just for those who are less familiar with the process, just so that you know, normally what happens is that the hearing would start at 10 o'clock on the first day, and we sit through till around about sort of 4:30. We take a sort of a break down the middle of the day of roughly an hour for lunch. And then on subsequent days, we tend to start earlier, and we are thinking very much that we would be trying to look for somewhere locally to hold the oral processes so that people can come and join or sit at the back if they wish to. Is there anything else on that element of timing before we move on? I don't think so. Okay. Right. So then in terms of dates, Mr. Hardy, I think you wanted to chip in with comments on dates, and I rather stopped you there and went.
Yeah, well, just to say, so 15th of June, cutting to the chase, we as a team can't do the 1st of June or the 8th of June because Samantha Oxley is in another inquiry. So 15th of June, I think we can do what needs to be done locally during that week. If there then needed to be a spillover virtually, that would be the week of the 22nd of June, or indeed the week of the 29th of June if we needed one day. If we were going to get a little bit further away, we could also do 1 or 2 days at the start of the week commencing the 6th of July, but hopefully we wouldn't need to have such a break. So our proposal, what we can do 15th of June, and then if we need 1 or 2 days, either the following week, 1 day in that week, the following week after that, or the week of the 6th of July.
Okay, thank you. Just before I sort of seek other parties' views, I mean, I just want to make clear, I mean, obviously, it's been announced that there may or may not be a bank holiday on Monday, the 15th of June, and I don't know whether that would affect people's availability that week.
Just obviously starting the 16th, if certainly in terms of travel, so it would be to start on the 16th. Sorry, when I've said the 15th, I meant the 16th.
Yeah, okay, right. And the other point I'll just make on that, and then I'll seek other parties' views, is that obviously today's hearing meeting, well, pre-examination meeting, is being live streamed and it's being recorded. The week of the 16th of June, we can hold in-person sessions, but we don't have facilities for either live streaming it or recording it. We're hoping that people think that that would be okay, given that we're likely to be holding the oral processes in the community, so people have got a chance to pop in if they want to see that. But that could be another complication if needed. But I think people are happy that we're going to be in person in the locality. Then we can sit with that possibility of the 16th of June. But let's just see what people's availabilities are first of all. So Murray Council, can I come to you first? What's your availability in those weeks?
We're fairly flexible in terms of availability during that time.
Okay. So you're available the week of 16th of June, and then we'd also talked about the 6th of July. I'm conscious once we hit July that we hit holiday sessions, and I suppose if there is a need to perhaps do 1 or 2 sessions remotely after the main hearing time or oral process time, to have an understanding of what people's restrictions might be.
Yeah, our preference would be to try and hit it by the end of June rather than go into the holiday period, but we can try and accommodate perhaps individual days.
Okay. Aberdeenshire Council, the suggestion might be that you've expressed a preference, obviously, for the conditions session to be held remotely. Does that sort of free up your availability?
It's not so much about availability; it just makes us easier to attend. Our preference are similarly in June and not to go into July. So I'm just because if it was July, it would have to be those first 2 days. This is it, 6th and 7th of July, because we then start eating into. I know I'm on leave from the 8th.
Okay. But the week that's been proposed,
That's definitely yeah. So we're supportive of the position of the applicant and Murray Council in terms of dates.
Okay, lovely. Thank you very much. Mr. Christie, any restrictions from your point of view?
Week commencing the 15th of June could be problematic for council, but we've inquired about wider availability in June, including the following week commencing the 22nd. So we'll be better able to feedback thereafter. Like others, the avoidance of July feels sensible, given how much activity is ongoing during July and collisions with annual leave. But yes, so we'll need to kind of revert on that one.
Okay.
How quickly can you do that?
Hopefully within the next 24 hours.
Okay, yeah. I mean, we appreciate people have preferred counsel, but preferred counsel not being available isn't necessarily a reason that we would shift the dates if that's more amenable to the majority of people to stick with other dates. So just it's worth noting that given the constraints that we've got sort of time-wise. Mr. Mackenzie, have you got any constraints? I think originally you said that week of the 15th was okay for you.
Yes, there's no constraints from me.
And if we have sessions that run after that week, what's your availability?
I'm completely flexible, so I will be available.
Okay, thank you. Mr. Cameron?
No present constraints and fairly flexible continues as well.
Okay, thank you. Right, well, we've set out in Annex B a draft timescale, which, well, we're hoping perhaps might still be possible if we can get an updated map in that short period of time. So just to sort of talk through then what these dates are. So by the 6th of February, we will be able to issue to you the note of this meeting. And we will be able to set out what our requests for further written submissions are, so that you're all aware of what information we need from you and when we need it by, which will be the 27th of February. And once you get those, once we've had everybody's further written submissions, you have an opportunity to comment upon them. We will be looking for some guidance and help from the applicant in getting various bits of information together, which includes a list of foundation documents. Just typing my notes to remind me what the foundation documents are.
Foundation documents are essentially the list of application documents and anything else that's on the DPA libraries. So it's more like policy documents that we probably think all parties are going to refer to. The applicant produced a first draft of that with a position statement. But what we encourage the applicant to do is to make sure that any parties have got anything else to add to that foundation list, limiting it to the document from the DPA libraries, that they do that in this time frame and submit it back to us. So that's kind of a baseline of foundation documents. It does allow parties to then submit their supporting documents with their inquiry statements and hearing statements in due course. So it's two different foundation documents are pretty much application documents and library documents. The supporting documents are anything else a party wants to refer to, which you may produce photos, media, maps, other pieces of evidence that you want to use to support your own case.
So by sorry. We'll be also looking to ask people to suggest to us locations for site inspections, and we'll ask you to send in a list of those suggestions at the same point that you come back to us with your answers to our further written submissions. We'll be requiring a statement of agreed matters, and that should set out those issues where there's agreement between the applicant, the Moray Council, Aberdeenshire Council where appropriate, and third parties. And as we've been discussing, draft agreed conditions, again, will be agreed between the applicant, the two councils and third parties as far as possible. And this statement of agreed matters and the draft agreed conditions we're hoping could be submitted by the 13th of March. And then where there are differences, where the draft conditions can't be agreed, we will be looking for a document setting out the areas of disagreement and or alternative conditions so that we can consider what needs to be discussed at a hearing session. For the inquiry sessions, we're going to require inquiry statements from those who are participating, and that will set out the particulars of the case the party intends to put forward and a list of the documents which they're going to refer to. And we'll also specify the witnesses who will give evidence and the scope of evidence that they're going to cover and who will be leading the case and cross-examining. And we anticipate that that would need to be provided to us by the 17th of April. And then in addition to that, each person giving evidence in the inquiry will need to lodge a precognition. That's the witness's written statement of evidence, and that should be no more than 2,000 words. And we anticipate that that would be required by the 29th of May, assuming that we go for this week of the 15th of June for the hearing, the inquiry sessions and hearing sessions. For the hearing, we need slightly different information. Those parties taking part in the hearing may be asked to produce a hearing statement, but it's likely that we'll also rely on the further written submissions and use those as hearing statements. We can confirm that once we've had the further written submissions. If we did need hearing statements, we're probably going to need those by the 8th of June. It's not much, the 8th of June. 17th of April, sorry. It will be set out. It is quite a structured process. We'll issue agendas in advance of any hearing session to give parties ample time to prepare. And after the inquiry and hearing sessions are finished, we will ask people to provide us with closing submissions. The council and other parties provide their submissions first, and then the applicant provides theirs about a week later. And currently the target date for reporting to ministers is the 24th of August. So Alex B has got the various dates down the left-hand side and the different documents that we're going to need at different points. I think at this point, given that we have a slight uncertainty about how long it's going to take for this updated map, are people content at the moment that those dates are going to be achievable with their own personal timescales, or is there any concern from anybody about meeting those at the moment? Mr. Hardy, can I start with you?
Yeah, yes, you can. The obvious point is in relation to additional information and potential difficulties with consultation. So the way around that would be for us to make a request and for you to say that for the purposes of the inquiry that was required. And in that way, presentation of updated information on cumulative effects could then fall in line with this timetable. And the obvious point is if that didn't happen, then there would be, I think, some difficulties in relation to consultation requirements for additional information. So I think what I'm saying is the map to be produced, and then it would be us requesting for you to direct additional information on those matters that you think you would need to hear for the purposes of the inquiry. If we do that, then I think this timetable works.
Just to be clear, you're not suggesting that we send out an initial further written submission requesting you to update that map. You're just going to volunteer it, and then on the basis of that, we send out our written submission. Or would you like a written instruction?
Well, actually, if you were able to do that, that would, and if that was going to be additional information in itself, which it probably would, actually, if there was a request from you, having heard what we've got to say, I think that actually would be a good idea. So I think in terms of the note, if you were able to indicate that there was a request for that, for the map, and then once that's done, the other things will follow in train, I think that would be very helpful.
I think we'll think about it.
We'll think about it, yeah.
Just thinking through the timescale for that. What would your anticipation be of submitting the additional information once requested? Are you thinking that would be submitted at the same time as other supporting documents or in advance of that?
That would depend on whether you think cumulative information is required in relation to other topics. And I'm thinking there about water and hydrology, and that I haven't taken instructions, I'll confess, because the indications were, for the reasons you know, that nothing further was required. So I don't know how long that would take. Once the map had been produced, it is then going to be a case of, a cumulative assessment. I imagine just from past experience, that is not quick. It's going to be a month or 6 weeks or something like that to produce it. So I would suggest that might come in with by the 7th. by the 17th of April.
I guess what we're a slight difficulty there is that the other parties won't have seen this information. So
Yep.
their inquiry and hearing statements are potentially based on a position that's maybe no longer the same. It's what comes out in the cumulative information. So
Yeah.
we're kind of the apples and pears situation, and it's how we kind of time that so there's time for people to see this information
And then be able to respond. Yeah.
Yes.
I
Yes.
wonder whether I mean, at the moment, we've got the note of this meeting and request for further written submissions isn't due to be issued until the 6th of February, but perhaps a way around that would be immediately after this meeting if we send out an initial request for that map.
For the map. Yes.
And that buys us a couple of weeks whilst we're still sending up, preparing the notes of the meeting for you to hopefully prepare that map.
Yeah.
And then we can take the next step of further written submissions in the order that they're appearing
Yes.
on here and make changes as necessary, if necessary, based on the information that we get from that map.
I think that's very sensible. And, what I can say is that, the applicant is going to do everything we can to help. This is, we want this to be heard in this time scale, and we will do everything we can to assist, assist you as reporters in that. And that means, I'm still on taking instructions, and we are still waiting to hear from Sam. It may be that she's not available today, but as soon as we do that, and if that's today, then we will be writing into the unit today to tell you when what she's told us about the time required.
I think we'll just have to think about that. Okay.
Yeah.
Let me take some views from other parties. Assuming that information is available, Murray Council, how does that overall timetable look for you?
Yeah, I think we'd be happy with it, thanks.
Okay. Aberdeenshire Council, you consent?
I'm happy.
Yeah, thank you. Turn now to those in the community, because I appreciate this probably isn't your day job always. So, finding time to participate is a little harder. Start with you, Mr. Christie. Does that overall timetable look possible from your perspective?
Absolutely. This will be a challenge for a small charity such as ours, representing a wider community. But respect the timetable that's been presented. Agree that kind of the knock-on effect associated with the revised map and potential knock-on in terms of EIA could be significant, which may knock timetable altogether. But we wouldn't know that until we've seen that presented.
Thank you. Mr. Cameron, does that overall timetable look possible?
Overall timetable was feasible. Obviously, as information becomes available, if it's on time, then it shouldn't be a concern.
Okay, thank you. And Mr. Mackenzie?
Yes, it's fine with me.
Okay, thank you. Well, I think we need to go away and have a think, and obviously there's a certain degree of uncertainty in terms of when we can get the map and what might arise out of that in terms of whether it has an effect on the timetable. But certainly if we can get that before we send out our initial request for further written submissions, that would be helpful, because we'll be in a better position then to know whether we're having to rearrange timescales and exactly what sort of work we're going to be asking different people to do.
We will definitely do that.
Okay, thank you very much. Anything else on timings? Okay. So I think that takes us to site inspections, and you'll see from the table in Annex A that we've indicated that we will take some site inspections in relation to some of the topics, particularly in relation to landscape and visual, cultural heritage, community effects and noise. Wherever possible, we will do these as unaccompanied site inspections, but there might be places, for example, where there's access required to private land, which has got restricted access, or if there are particular features that people would wish to point out to us where an accompanied site inspection might be more appropriate. We'll be giving you all an opportunity for parties to respond in writing, but at this point, it's just helpful for us in terms of our planning to know if there are any particular viewpoints or places that people would want to especially bring to our attention as part of our site inspections. I'm going to start with you, Mr. Hardy. I may. You can reserve judgment for another point if you like.
No, we thought about this and prepared, or we've put together a suggested itinerary. I don't know whether you, whether you want the detail of that, but it's starting in Dufftown. In order, we are saying VP 18, VP 16, VP 19, VP 1, the site, VP 2, VP 13, VP 3, and VP 4, finishing in Dufftown. That's been put on a map, and obviously we can circulate that. I've already indicated that we will prepare high resolution figures that identifies and names the exact the viewpoints on one clear ordnance survey base to make that as user friendly as we can. And we don't have a strong view. We don't think it's necessary to have accompanied site visits. There may be, in this case, because of heritage, it may be that that's thought useful to have accompaniment. We're not suggesting you need to, but we will fit in with what you think.
Thank you. And I noticed you mentioned the site in there. Are there any restrictions about access to the site that we should be aware of?
So that would be via existing tracks and paths. There's obviously forestry operations going on, so we would make sure that that was safe and notification had been given.
So we'd need to notify you in advance so that that could be clear.
Yes.
Thank you. From a council's point of view, you may not have any comments at this point, may want to get your landscape advisor involved in terms of whether there was anywhere in particular you had thought that you felt would be important for us to visit.
Just in general, we'd give us more thought, but as a starter, the viewpoint 6 Benrinnes is really something important to get a handle on, just like the cumulative issues across the landscape. Similarly, the viewpoint 13 at Baudelaire is important from a cumulative perspective, and that's essentially brings a transboundary element between the Shire and Moray. And lastly, just to highlight really viewpoint 18 and the cultural heritage viewpoints from Auchindoun Castle itself or nearby be important to view from the Moray perspective.
Okay, thank you. Anything from Aberdeenshire Council's perspective?
Not on this topic.
Okay, thank you. Mr. Christie, any initial thoughts? Places we should visit as part of our site inspections?
Over and above the existing viewpoints, we can kind of review the itinerary and location cited by Mr. Hardy with council and revert from there. The Distillery and Heritage Centre now operational may be worth considering, as it was but a derelict steading when the initial assessment was done.
Okay, thank you. Mr. Mackenzie, any initial thoughts about where, as I say, you have an opportunity to comment in writing, but if there's anywhere that immediately you think we should certainly think about including? You're on mute, Mr. Mackenzie.
Yes, thank you. I put those in my position statement. I made some suggestions there. Not all of them are formally identified viewpoints. Obviously, they don't fall under these VP numbers. Some of them do, but the others are key views, in my opinion, which just have to be seen because they are what the community will experience and are the most cherished views, in my opinion, within the area.
Okay, thank you. Mr. Cameron, do you have any?
Yes, I would like to review Mr. Hardy's visit proposal and then probably make comment in writing after that if any other additional areas required.
Thank you. And okay, well, we'll do that as part of the written submissions, whether anybody feels that any of those viewpoints that they identify, they feel would benefit particularly from an accompanied site inspection rather than an unaccompanied. But I think we'll be working on the basis mainly of unaccompanied site inspections. There's strong reasons otherwise. Okay. It takes us to point 10, just in terms of contact with us going forward. I think you've all probably been contacted already by Laura Walker. She's the case officer for this inquiry process, and so any correspondence should be done with Laura initially. I noticed the comment from Mr. Hardy about exchanging of emails, and I think we'll be asking Laura to just check that other parties are happy to share their email with each other. It just makes the exchange of documentation much easier, so that when you copy something to Laura, you copy it to everybody, and that means that people get information as quickly as possible. And equally, everybody knows that they have all got the same information that everybody else has received. Does everybody think they'll be happy to share their email addresses afterwards? Yeah. Okay. Thank you. As I said, we'll be preparing a note of this meeting, and we'll hope to issue that by the 6th of February, and it will include confirmation of the further written submissions that we require with the dates for when we require that information, our decisions on the topics to be dealt with by hearing or inquiry sessions, if we're in a position to do that based on the information that we've got, the dates for lodging hearing and inquiry statements and documents, and the dates for lodging any precognitions for the inquiries. Obviously, they're not required for hearings. And we'll provide an updated version of Annex B inquiry timeline, bearing in mind we might have to tweak that depending on what comes out of the cumulative impact assessment that we're going to get. So you'll be pleased to hear we're virtually at the end, but I just want to check in case there's anything that anybody feels that we've missed, or that they felt that they ought to be covered in today's meeting. So I'm going to start with the community representatives first and work my way up to the applicants. So, or down to the applicant, whichever way you tend to look at it. No value judgments in that. So if I can start with Mr. Mackenzie, have you got anything further that you felt we would like to have covered today?
Can I just ask if there's any limitations on the emailing of documents in terms of file size that we should be aware of? Because image-intensive documents tend to be very large, and I've experienced a lot of problems with the energy consents units limits. Are there similar limits with the DPA website or web system? So if that could be clarified, because if you make a video file or you make an image-intensive multi-page document, it can soon exceed a fairly modest, would be considered a fairly modest document size, and therefore can't be emailed. The system just blocks it.
Yeah, what we tend to do, if there are a lot of big documents expected, we will set up an Objective Connect site that people can upload documents into there, and then we put them on the case management system. But Laura would be in touch to discuss that and logistics of doing that. But that's what we tend to do. It's kind of like a holding place. All parties have access to that Objective Connect site as documents are going on to the case management, but allows you to upload, as you say, big files, or maybe it would be more difficult to email. But we can send out guidance with that on the pre-examination note of this meeting. Or Laura will circulate something separately just to give you guidance on how we could deal with that. But there's a way of dealing with it so you can load bigger files.
Yeah, we'll make sure that that's covered in the PM note. There won't be any need for anybody to send us anything until you've got the note anyway, because the note will set out what we're expecting from people. So it won't hold anything up, so we can do that. Thank you for your question. Mr. Cameron, any questions from you?
No further questions. I think all the points have been covered.
Lovely, thank you. Mr. Christie, anything from your side?
Nothing from my side other than to thank you all. Thank you for the meeting.
Okay. Aberdeenshire Council, anything from your perspective?
Yeah, nothing. Thanks to everyone.
Okay, thank you. Murray Council, anything from you?
Nope, thanks very much.
Thank you. And from the applicants, is there anything, Mr. Hardy, that you think we've omitted to cover?
No, I think it's been comprehensive apart from this. That's potential venue for the in-person sessions. I don't know whether you want to just touch on that.
Certainly, if anybody in the community has any ideas of a location that can host an event, we'd be very happy to.
The Glass Community Hall is what we have thought.
Okay.
The alternative might be the Mortlock Memorial Hall in Dufton.
Mr. Christie, you've got your hand up. You've got a suggestion.
Yeah, kind of one of our community assets that the Cabrick Trust has responsibility for is the Acorn Centre, which is the community centre and hub, probably in closest proximity to the development. As we have responsibility and control over it, I'm certain we could explore its availability for hearing and inquiry sessions.
Okay, well, thank you for those suggestions. We'll be asking Laura to explore options because we have some, quite specific requirements in terms of accessibility and so on. But thank you for raising that, Mr. Hardy, and we'll get Laura to have a look into those as possible venues.
Super.
Okay.
Other than that, no, thank you very much.
Thank you. Anything from your side, Trudy? Okay. Well, thank you, everyone. Nice to meet you all virtually, and I'm sure we'll be meeting you again, either virtually or in person throughout the rest of the process. But for now, that's the end of the pre-examination meeting. Thank you very much.